is of and concerning him. But the fact that the plaintiff is not even named in the article doesn't mean that the publisher is off the hook if the plaintiff can be identified from the context and so on. And then there are occasionally issues about of and concerning. Say, if somebody writes that Facebook is defrauding its customers by doing such and such and such, does that defame Mark Zuckerberg? Or if the article says Mark Zuckerberg does such and such, which is illegal, immoral, does that defame Facebook, the company? And the answer to that question is no. Even though the public, those questions, even though the public tends to think of Zuckerberg and Facebook as one and the same, they are separate legal persons. The corporation, remember, is a person. And person defamed is the only one who can sue. Zuckerberg can't sue because Facebook is defamed. Facebook can't sue because Zuckerberg is defamed. And then there's another rule that deals with the of and concerning, and that is the group libel, where the libel defames an entire large group of people. Well, the courts have decided that large groups can't sue. Only individuals can sue for damage to their individual reputation. There's no such thing as a class action for libel. And that's why Muslims, for example, can't sue for those muni posters. It defames millions and millions of people. So the fact that you happen to be a member of that group does not entitle you to sue for libel. And then the other element of, why did we lose that? The other element of common law libel that we haven't touched on is the one that decided the Dorsey case, that the statement has to be unprivileged. It's part of the definition in the statute. Libel is a false and unprivileged publication by writing. Well, there are a lot of privileges in the law. Some of them are evidentiary, like husbands can't be forced to testify against wives, doctors against patients, and so on. That's not the kind of privilege we're talking about here. There are privileges in the law to commit torts. You're privileged to assault somebody if you're doing so in self-defense, for example. It's a defense to a tort suit that you are privileged. Well, in libel, there are two privileges that you ought to know about that protect you from being successfully sued for libel. One is fair comment, and fair comment involves the expression of opinion, honestly held, you have to really believe the opinion, about a matter of public concern. And the fair comment privilege entered the common law sometime in the early 19th century when a court decided that a book review written about a book that had been published was privileged in the opinion that the book was terrible. Nobody should read it. It was no good. It was not right, adequate, well written, whatever they said, that defamed the author of the book. That was privileged because it was fair comment. People could make up their own minds about whether the comment was. They could read the book and decide whether it was fair comment or not. It was an expression of opinion, not fact. And that has been used since the middle 19th century to protect all kinds of expression of opinion, especially in opinion columns. Restaurant reviews, for example. The food is terrible. It lacked taste, or it tasted like acid. It's expressions of opinion that the reviewer honestly holds about a matter of public concern. How good is this restaurant? How good is this book? Even political opinion is protected to some extent. The question is the expression of opinion provably true or false? If it's so factual, Turner murdered his wife. If it's so factual that it can be proved true or false, then it can be libel, even though it's framed as opinion. I think Turner murdered his wife. Does not protect the opinion, because the substance of it can be proved true or false. And the other privilege is the fair report privilege, which also grew up at common law. And privileges allows you to escape liability if you are making a fair and accurate report in a public journal, certainly includes newspapers, radio, television, and I would think these days blogs. If you're making a fair and true report, an accurate report of what goes on in a judicial, legislative, or other government proceeding. Actually, the California law says other public proceeding. So if what you're reporting is what goes on in court, somebody testifies that they saw Turner murder his wife, the newspaper can report that testimony and be privileged in doing so, even though the reporter knows it's not true. Knowing that it's not true doesn't mean that the privilege is lost. It's an absolute privilege. Same with anything said on the floor of the legislature. You're reporting something that goes on in the legislature, and you're privileged to republish what is said there without worrying about getting sued for libel. Camille?
Would like a Facebook status on a tweet be considered a public journal?
Good question. I don't know that we know that yet. I would argue that it is, in the sense that it's something that is available to a large audience, not to a particular. It's not a private conversation. It may depend on how many people have access to it, what kind of filters there are on it, but I would say that a tweet would be covered by the public journal language. It's an amazing tool to protect the press, the fair report privilege. You can say all sorts of uncomplimentary things about people if it has been said in court, the legislature, or in some other public proceeding, and not have to worry about getting sued. And the reason for that, I suppose, is that the courts have considered that it's more important that we all get to learn about what is happening in our courts, our legislature, and our government, more important that we be informed about what's going on there, than that the individual whose reputation may be tarnished gets compensated. The judgment of social costs and benefits that strongly favors freedom of speech. Well, why did Dorsey lose his case? He was tested right after the lawsuit was brought by a doctor hired by the Inquirer. He was tested, and lo and behold, he didn't have AIDS at all. It was flat out false, the article about him. He didn't lose because he wasn't negatively affected, that he didn't suffer damages, because he may well have suffered damages. The Inquirer did not know that it was false beforehand, but that didn't matter. If it was in fact false, knowledge of falsity at common law was not an element of the tort. Different under New York Times versus Sullivan. But at common law, the publisher did not have to know that it was false or have any intent to hurt the plaintiff at all. Malicious or otherwise, it was, at common law, a no-fault tort. I put up the question about fault. Well, most torts, legal wrongs, require the proof of some blameworthy state of mind, that you've done something that is blameworthy. You intended to hurt somebody. You intended to cheat somebody. You acted negligently. You had fraud in mind. You had malice in your heart. And in most torts, I mean, in assault, you had to have an intent to hit the person. In fraud, you have to have intent to cheat the person, and so on. Negligent, you act not as a reasonable person would in the circumstances. You're blameworthy in some way. Well, at common law, libel was a no-fault tort. You didn't have to prove that the publisher knew anything or intended to do anything. All you had to do was prove that it was false, defamatory. You didn't have to prove it's common law false. It had to be false, defamatory, of and concerning you, and unprivileged. Yes, it had to be false in order to win. Exaggerated, well, we all exaggerate, would not result in liability. It had to be false, untrue. And then goes beyond the court case. Well, that's what Dorsey argued, that what the Inquirer did was not simply report what was said in court, but went beyond what was said in court to interview Kathy Jetter, where she elaborated on what the allegations were in court, and they interviewed the private investigator who embroidered the situation, talking about he's been treated at Sloan Kettering Hospital and so on, which wasn't in the court proceedings. They went beyond that. Well, how did the court deal with that? The Inquirer was saying, we are privileged, under the fair report privilege, to report not just verbatim exactly what was said in court, but we have some breathing room, and the court agreed. We have some literary license to explain beyond the four corners of what was said in court, to explain the context and make it interesting and understandable to the public. And the court said, that's right, as long as they don't go beyond the gist or sting of the information that was submitted to the court in adding to what was in court. As long as they don't go beyond the gist or sting of what was in court, then they're protected by the privilege. Well, what was the gist or sting of the court proceeding? It was that Dorsey had AIDS. That was the gist of the allegation, the case. What was the gist or sting of the material that went beyond what was said in court? He really does have AIDS. We're sure. We're 100% sure. But that doesn't add to the gist. It's still the same. The guts of it, the gist or sting was he had AIDS. Therefore, they were still protected by the fair report privilege. Dorsey also argued that this wasn't within the terms of the statute. This wasn't a public proceeding because family court in New York is private, is secret. And what's said or done in the New York family court is not public. And that doesn't fit within the privilege. And the court, referring to California precedents, interpreting the California privilege, said, no, that doesn't matter. As long as it's an official governmental proceeding, it doesn't have to be in public. And they referred to precedents that involve, for example, FBI rap sheets or secret grand jury testimony, which are not public, but which the California courts had held are within the privilege. So that Dorsey lost his case, even though what was published about him was false, was defamatory, and may well have injured him in his occupation, because the Inquirer was privileged to report that falsehood about him. Does that trouble you? You okay with that? Are you so imbued by now with freedom of speech and the press values that you can't sympathize with poor Engelbert having been defamed and let him off the hook? Okay.
I think that's to show the weaknesses of the media industry in America, because if we can just report on this and nobody reports the other side of it, that the fact that he doesn't actually have it. I don't think a lot of people still know that. I think there's probably still a question out there.
Yeah. No doubt that he's been hurt and that the media are responsible for it. At least the Inquirer is responsible for it. Certainly didn't correct in the public mind the impression that was left by the inflammatory article. But as I say, with the public policy behind the privilege is that it's more important to allow the press in particular, and all of us, to publish what our government is up to, so that we're all informed what our government is up to. That's a more important value than the reparation of a single individual's reputation, because the press goes a little too far. Ruby?
So for 5B, actually on government proceedings, so what if a tabloid publishes, like,
What if what?
the 5B refers to only government proceedings? Like,
Yes.
So what if like a tabloid publishes an article about, oh, he's a drunk and he beats his wife? Like, is that a public, can that be seriously libel?
Yeah, there's nothing, you're not reporting that he was convicted of public drunkenness or convicted of domestic violence. You report, not, if you were, that would be protected. If you're saying that Turner is a drunk and beats his wife, what privilege could apply to that? Not the fair report privilege. No other privilege could either. Nicole? No, but they were reporting what happened in this judicial proceeding in New York. That there was this case filed, and here's what the allegations were. Watch for it in all reporting. You'll see it frequently. The government yesterday indicted so-and-so, and the indictment charges the defendant with this kind of fraud, securities fraud, or whatever it is. But pure and simple, privileged reporting of what was filed in court. Whether it's true or not, the law doesn't care. The law will protect at least some false speech. And the First Amendment, as we'll see Tuesday, protects some false speech. So I'll see you Tuesday.